Well, hello everyone, and welcome to Uncivil Law for our weekly law roundup and hangout with our good friend, Nate the Lawyer. Say hello, Nate the Lawyer.
Hello, Nate the Lawyer.
Yes.
I love these dramatic entrances.
Yes, we're here with some wonderful law news and law roundup, and I think a fair amount of time will be consumed with some catch-up and preliminary thoughts on the Chauvin Floyd ongoing trial in Minnesota, because that is the topic du jour. As the trial gets its preliminary stages underway, the court has considered a number of motions in limine. I don't believe they've actually started jury selection yet, as I understand it. They were supposed to. That has not happened yet. But that will
they
happen.
Picked three jurors.
Did they? Okay, then I'm mistaken. I missed a memo there. I was under the impression it hadn't actually happened. But yeah, we had the motions in limine, and we had some initial jury selection, I guess, and that will continue presumably throughout the rest of the week, if not longer, depending on need. And then we'll go to trial. And also there is an appeal ongoing as to whether or not the prosecution can present third-degree murder. And it's a little bit weird to have the trial ongoing while an appeal related to that trial is also ongoing. Yeah. The idea of appealing something in the middle of a trial is not completely unknown. We call it an interlocutory appeal, but it's a little bit weird for them to be running in parallel. So that's a thing that's apparently happening.
Looking at the case now, looking at the third degree, the wording is funky.
Yeah, the wording is funky.
We should pull it up so people can know.
Yeah, that's always a good idea. Why not actually go to the statutes and actually read them and present them? These are deep ideas from our friend Nathan. So yes.
While you're looking it up, I'll explain what the problem seems to be. The law was written for the drive-by shooting, right? So you're supposed whatever you're doing that's dangerous has to be dangerous to people kind of indiscriminately. You can't really be directed at one person. It's dangerous to me, to Kurt, whoever's in that area, the drive-by shooter. But in this instance, George Floyd, this wasn't a drive-by shooting. This was kind of an intentional killing of one person. So since you don't have that element of the criminal act being applicable to everybody, was directed at one person, then the defense was saying that this charge isn't relevant to this particular defendant because this is not like a drive-by shooting. So that's why the third degree is now going up on appeal, because both the trial court said, the trial court threw it out, the appeals court put it back in, and now they're going to the state Supreme Court. But go ahead.
Yeah, so we have two different definitions for murder in the third degree, and we'll start with B because that one doesn't apply, so we can dispose of that fairly quickly. So definition B of murder in the third degree in Minnesota says whoever without intent to cause death approximately causes the death from selling or distributing or giving away a controlled substance in Schedule 1 or Schedule 2 is guilty of murder. So this is if you are the seller of a Schedule 1 or Schedule 2 drug and someone dies as a result, that's third degree murder. Obviously, that's not the charge here because no one is arguing that the police gave Floyd drugs or sold him or otherwise, were the ones that offered it to him in some way. So B does not work at all. So then we're under definition of A. And this is how Minnesota defines third degree murder in its jurisdiction. And as always, keep a reminder that different states define things differently. So we're only talking about how Minnesota defines it. And Minnesota defines third degree murder in Part A as whoever, without intent to effect the death of any person. And that's a tripping language here when it comes to Floyd, because one of the elements is the idea that the intent was somehow focused on Floyd. So in third degree murder, the way it reads is, okay, we're not intending to effect the death of any person. Causes the death of another person by perpetrating an act eminently dangerous to others and evincing a depraved moral without regard of human life. So yeah, there's two problems here. It's like, how do you say he doesn't have intent to affect the death of any particular person
when he does?
And how is it eminently dangerous to others other than the person who died? That's a problem. So when you say, well, the way that others has been interpreted, as I understand it, is people other than the person who died. So yeah, this is a drive-by statute. And this is what it was built for, although not exclusively used for this purpose. The idea is you are causing a risk that's dangerous to a group of people in a sort of undifferentiated way, and without intent to cause the death of any particular person, because if you're trying to kill a particular person, that's second degree murder or first degree murder maybe, and intent follows the bullet. So if you're intending to kill person A, but you kill person B, it's still first or second degree murder because intent follows the bullet. So the premise here is that you're not intending to kill anyone in particular, but you're causing a risk of inherently dangerous risk to a group of people, and you're not intending to cause death of any particular person, but someone dies. So it's really hard for me to see how Floyd's death falls into A. I don't get it.
I think this is a recklessness standard, right? The dangerous act, driving the car into the crowd, not knowing who it's going to harm. But I do think if just reading the statute as is, it doesn't seem to directly tie into the Floyd killing. And again, for the points that you made, but again, it's not what the law says, but it's how it's interpreted by the courts, right?
Yeah, of course, it's a legal question. Appellate courts, questions.
And the appellate court says this applies to this scenario. Maybe it's saying that but I still don't know how you get over the which is that causes of death. It's a difficult read. I can see it going either way.
I'm having a tough time squeezing that we can do this into this.
Well, this imminently dangerous to act. This whole pertaining to an act imminently dangerous to others. That's where I think you lose, right? I mean, the prosecutor loses, right? How was the act that he did imminently dangerous to anyone else except for George Floyd?
Yeah, apologize. Watching You Daily says the Supreme Court has denied to hear this appeal. Okay, and there are 4 males and 1 female on the jury, 3 white and 2 of color. Okay, well noted. So far, that appears to be the composition. But yeah, I was under the impression the appeal to the Supreme Court was ongoing. So if the Supreme Court denied it, that's new information that I did not have.
So George, so they're going to charge him with this
again. With the second, yeah, I don't think third degree murder really works. And we can also look up the second degree murder statute as long as we're here, because that's the one that we're charging him under. Principally, and of course there's also the manslaughter, but the principal charge we're looking for is
you got to control F, baby. Homicide. Control F.
Calm down, I'm getting there. We're getting there. All right, so yeah, then we also have intentional murder and drive-by shootings also in subsection 1. So we also have that in that situation.
But hold on. Can I say one thing? Why couldn't they do this for third degree murder and make it so much easier for us to read, right? And to do this? It would have been so easy, right? Third degree murder could have been laid out just like this. Legislatures, if you're watching, please make it easy for us.
I don't know. So apparently drive-by shootings specifically are second degree murder, but if you're otherwise shooting into a crowd of people, it's third degree murder, because somehow those are different in some way. Don't ask questions. It's just how they defined it. And then we're obviously under subsection 2 for unintentional murders. And then subsection 1 is where we're in causing the death of a human being without intent to effect the death while committing or attempting to commit a felony offense other than sexual conduct in the first degree with force or violence, or drive-by shooting, because that's subsection 1. So that's basically what we call felony murder in short. Death that occurs in the commission of a felony is where we're at. The underlying felony that's been charged is felony assault. I don't believe Chauvin has been charged with felony assault unto itself. He's only been charged with the murder and manslaughter. Am I incorrect? Is the felony assault also a pending charge?
Let me look at the let me see if I can find the indictment.
Yeah.
But I would suspect he'd have to be charged with something.
Well, no, you don't necessarily have to be charged with the underlying felony. You just have to prove the underlying felony as an element of this offense, but you don't actually have to be charged with the underlying felony.
I'm surprised you don't want to. Well, maybe, but they don't have merger doctrine here. I don't know.
Yeah, well, I know, but but strictly speaking, you don't have to.
Yeah. No, I didn't download it. I had to look for it. But you're right, though. I don't know what. You know what? This is simple Google. What am I talking about? Looking at the thing. Derek Chauvin's charges.
Yeah. And I'll look up the definition of felony assault while you're looking that up.
It's put me behind a paywall. It's like the first 5 things are paywalls. All right, I think I got it. All right. Second degree murder, second degree manslaughter, third degree murder, but that's the one in flux. And that's it. I see no assault. I'm looking at it right now. Count 1. 1 was second degree murder. Count 2 was third degree murder. And count 3 was second degree manslaughter. So they're not charging the underlying offense.
So is it third degree assault that we're going for?
No, they're not. Well, it'd have to be they're gonna have to show an underlying felony. So the underlying felony.
Yeah, I'm just trying to figure out what is the actual underlying felony they're going for.
They don't list it. But I'm assuming
they don't list it on anyone.
No, there's only 3 counts: second degree murder, third degree murder, and second degree manslaughter.
Well, third degree felony, a third degree assault looks possible. Although it's unclear if this is a felony or not in subdivision 1.
Usually, you can tell if it's over a year in prison.
Yeah, but the way it's actually written, I'll show you why I'm confused here for a second, because it's a little bit unclear. When the third degree felony assault, they say in subsection 1, 5 years, which suggests a felony, but then in subsection 3, it say felonies. If in the case of a victim under the age of 4 and bodily harm, it's a felony, which implies in subdivision 1, it's not a felony, even though it's a 5-year sentence.
I'll just say this. Crimes are usually defined by the amount of time you can possibly get.
Usually,
felonies or maybe in Minnesota, again, that's why they have different law practices. If you're getting 5 years, that's not a misdemeanor. That's a felony.
Well, no, I mean, some states define felonies pretty weird.
Yeah.
But with assault in first degree, whoever assaults another inflicts great bodily harm. I think that's first degree. So let's say it's first degree. Whoever assaults another and inflicts great bodily harm can be sentenced to 20 years. Okay, so we assault another and inflict great bodily harm. Well, we've got great bodily harm because he's dead. So that works easily. And then we have the underlying assault question.
But then why not charge him with these underlying felonies? Because these give you more bites at the apple, right?
I guess you can prove any felony. So it gives you flexibility in case you dream of something else along the way. But first degree felony assault looks like the one that is most applicable. You assault other and inflict great bodily harm. The person died, so that's pretty much great bodily harm. Yeah. And then you're just into the question of whether or not there was an assault. So we're trying to prove 2 things in the Floyd case. We're trying to prove felony murder. So we have 2 different things we're trying to prove. The felony and the death was result or caused by the felony, a causal connection.
So the felony was in the commission of the crime. I mean, the
felony would be the felony assault, first degree assault. So the felony is presumably first degree assault. We assaulted another and inflicted great bodily harm. And the death that resulted was from the felony assault.
Yeah.
So we're trying to prove those 2 things. So the defense can attack this from one of 2 angles. They can either disprove either half of that. Disprove the felony or disprove the causal factor. So let's deal with those in reverse order, because I think
hold on. Say that one more time. You could disprove the felony or the causal factor. The felony,
if he didn't die from the felony,
doesn't matter, because that's the bank robber thing. That's dying of a heart attack
in the bank robber
robbery
situation, it would be that the person died of a heart attack solely because of things unrelated to the bank robbery. If the reason the person died had nothing to do with the felony, then it doesn't count.
Yeah, but I'm saying that's because I'm trying to figure out how would you prove that if someone had a heart attack, unless they had the heart attack before. That's the only way. Like if you have the heart attack during somebody robs the bank and then you have the heart attack, I don't see. I
don't know how you prove it, Nate. I'm just saying as a theoretical matter.
Okay.
Theoretical issue, right? So how you prove it is a whole nother set of problems.
Yeah, as always. All right.
But that's true. As a purely theoretical exercise, if you could somehow prove that the heart attack was completely disconnected from the bank robber storming into the bank with guns blazing and say everyone dropped to the floor, if you could prove the heart attack had nothing to do with that, then it doesn't count because there's no causal relationship to the felony. Now, how you prove that is a whole different set of problems. But as a theoretical exercise. Now, it's slightly less a theoretical exercise in our present situation because we do have some evidence that might suggest, and there's plenty of evidence to suggest otherwise. So what we're trying to prove, let's make this clear, is that the reason Floyd died, if we're going to the causality, what we'd have to show is that Floyd died from reasons completely disconnected from what the police did.
Correct.
Because if the police are a cause, not the cause, not the main cause, not a major cause, but if they're a cause of the reason he died, they're host. So what you have to show is that they're completely unrelated. So that's tough, but the defense has some ideas that make it at least within, like, not quite as insane as the heart attack example. Yes. So here's what the defense has to work with. They have the fact that Floyd, in his Mercedes, in his center console, there were found tablets that were there were a combination of methamphetamine and fentanyl. And in the backseat of the police car, there was residual powder that was a combination of fentanyl and methamphetamine, along with DNA of Floyd. In other words, spit or saliva. And so it suggests very strongly that Floyd ingested some fentanyl, methamphetamine in the back of the police car, because otherwise, how does the powder residue with his DNA get there? So somehow he managed to consume this in the police car. Maybe it was already in his mouth when he was put in the police car or whatever, but somehow it was at least consumed in some respect in approximate time frame, because otherwise, how can it be there? So the idea would be that the defense would have to argue that there was enough meth, fentanyl, and other drugs in his body that was the, well, if not sole cause of death, that the police had nothing to do with it.
Yes, but I think the problem there with the fentanyl issue is that two things. Number one, he was an addict, so he had a higher tolerance. So watching some of these shows in sense of, it's just like heroin. If someone who's their first experience with it, they can't take as high as a dose as someone who's been using it for 10, 15 years. And on top of that, the person not high tolerance level, you have to detox to even get off of it. So obvious. So that amount, as both the state's medical examiner and the family's medical examiner, it was a cause, but it wasn't the only cause. And let's also make it very clear too, he did have other physical issues, hypertension, heart disease, so forth and so forth, which again goes to the eggshell plaintiff excuse, right? You take the victim as they are. So just because Mr. Floyd did have all of these elements doesn't absolve the person who attacked him of saying, oh, well, I did this. He would have survived if he was healthy.
That doesn't work. No, that doesn't work. That absolutely. Let's make it 100% clear. That absolutely does not work. It doesn't matter if Floyd was in some weakened condition, either naturally or artificially or self-inflictedly. If Floyd was in some weakened condition and he was more vulnerable than your average person, and the police did something that wouldn't harm a normal person, but did harm Floyd, the police are hosed as to the causality element. So the fact that he had fentanyl or meth or alcohol or literally anything else in his system, or he had a genetic condition, or he had a weakened heart from overeating, or fill in the blank of whatever. If it doesn't matter, if the police are a causal factor in him dying, the police are host. So to make this work, you have to show the police are not a causal factor. You have to show the police are irrelevant to the equation. Irrelevant. You have to show that nothing the police did exasperated his death, which seems a little bit difficult given the evidence that's out there, because at least one of the reports argues that there's a positional asphyxia because of the way that he was positioned and because of actions the police took, that exasperated his death to some degree, and that's all you need to prove. So the defense trying to say the police are irrelevant to the equation is a tough sell, but they do at least have an idea, because they can at least, without completely, they can argue with a straight face if they were so inclined that because of the fentanyl that he took or other things, that was the sole cause, or again, not saying sole cause, that's a little bit imprecise. To say the police are an irrelevant factor. It doesn't have to be the fentanyl meth is the only cause. It has to be the police are not a cause. So they can say some combination of factors, not including the police, caused his death. And they could try to sell that on the causality. It's difficult, but at least there's an idea there because of some of the information that's available.
If I were the police, and I know this is going to be hard for people to understand.
Yeah.
But as defense, on the defense side, I think I would be arguing justification. I would be arguing justification, but justification of defense. I would be arguing that they trained me to do this. And and you know, and the training materials, you know, and the fact that, matter of fact, let's pull let me screen share this. Because I have the training materials.
Sure.
Which Chauvin was
share with
trained.
us.
And you know, I think it's also an indictment on that police department. Here we are. So first, just so everybody understands what this document is, we have to give everybody an understanding what this document is. Yeah, I'll flip it. Give me a sec. Rotate clockwise. There we go. All right. There's some that are sideways, some that are. But what this document is that this is a training manual for law enforcement officers from Minneapolis. This was what Chauvin was trained to do, and the cops there were trained to do. So this is the full PowerPoint presentation on use of force. So in other words, you have both these. When you train at a law enforcement academy, you have two parts of the class. You have first the practical, which is you going out there and, you know, grabbing arms and the handcuffing, and then you have the classroom. You know, this is what you do. This is the way you hold the handcuffs. There's a classroom element. So these PowerPoint slides are for the classroom element, and you'll see there's even a schedule on here. So one of the officers put in a motion to dismiss based on justification, says that he was justified in doing this, right? Because the training materials actually encourage and authorize people to do this and made distinctions on how to do this. So you will see here the knee to the neck was actually, the department actually has training on this and described how to do the knee to the neck. Well, not the knee to the neck. Let me make it very clear. The leg to the neck. Let me be more precise. The leg to the neck. So if you do it, for instance, on the side of the neck, that wasn't even considered lethal force. That's considered less than lethal force. And if you put your knee or arm to the front of someone's neck, that's considered to be deadly force. So that's what this document is going to show. One of the officers actually put it in, but the judge denied it. But they are going to go for justification. They were doing what they were trained to do, and they are justified in using this type of force to subdue Mr. Floyd.
Sure.
Do I think this is a winning argument? I don't. I think this was excessive, but I'm just laying out the argument and the evidence that I believe they're going to provide.
Well,
that
that's
makes sense?
fine, and that's fine, and that can switch us very nicely into the first half of the analysis, which is the underlying felony, which is also part of this thing. So you can attack the underlying felony in two ways. You can say we didn't commit the underlying felony, or we were justified in some way despite the underlying felony, which is perfectly proper in a self-defense case, which I'm not saying this is. I'm just using it as an example. So your run-of-the-mill self-defense case, not this case, just a self-defense case, right? You have a self-defense case is you have shot a person and they have died as a result of that. Now, if you look up the literal definition of murder, in pretty much every state, that's going to qualify as some degree of murder, right? I have shot a person with intent, they have died. That's probably some degree of murder. And so when you so you'd say it's murder, but then of course, well, say strictly speaking, it's homicide, and then the question of murder comes in second because it is a homicide, and then what you say is yes, I committed the homicide, but it isn't murder because it's a justified homicide, right? So that's the end legal conclusion at the end of the day. That's justified homicide. Yes, you committed a homicide, but it's a justified homicide because of self-defense, as an example. And that might not necessarily be the only example. So you have the idea of justification. So, and of course, it doesn't have to be homicide. It could be assault. Yeah. You know, I was justified in punching you in the face because of, you know, threats against me, and so it becomes a justified assault. Or there can be other things where it's justified by law. So the way the police can attack the underlying felony is in one of two ways. They can say either A, we didn't do it, which seems a little bit difficult because it seems
We got the video.
Yeah, it seems like an assault by any reasonable definition, right? There's a knee. I mean, it's a knee on the neck. That qualifies as an assault. I mean, just from basic 101 principles of an assault. It qualifies as an assault, and there was grievous bodily harm. He died. So we didn't do it. Doesn't seem like it's going to fly. But we're justified in some way becomes a little bit more promising because the police, well, everyone has some elements here of justification, and the police might have a little bit more because of public duty, public duty doctrines. You know, we were acting in a public duty, and so the police can use force in a variety of situations that a normal person couldn't do because of the police's job. And so they have a little bit / a lot more flexibility because of their specific job. Some of this is from statute. So there's specific statutes that are in play that say, you know, for example, the police in effecting an arrest can use reasonable force, and then it becomes a question, what's reasonable? There's Supreme Court cases in play. What was the name of the Supreme Court case again? Remind me.
Graham v. Connor.
Yeah, Graham v. Connor. Thank you. The Graham factors from the Supreme Court from the 1980s about the police's ability to use force and their training materials and so forth and so on. So the defense's options seem slightly better, and you convinced me on this because I previously, before talking to you recently, thought the defense's options were better on the causality factor. But you've convinced me that actually the defense's options are better on the underlying felony factor, that they didn't commit a felony because, you know, even if they went beyond the strict confines of the training, they acted in a reasonable way, as would be viewable by a reasonable officer in that situation, which is Graham. So not an ordinary person, but what a police officer would believe to be reasonable under the circumstances. And so they actually have better options in saying, well, we were justified in our use of force under the circumstances, even if we would departed from the strict confines of the training manual. So they have better options there.
But there's two things, though, is that this training manual, the sick part about it is that I think this training manual gives you enough to really question whether these officers are liable or not, in the sense of, well, let's look at it. Let me show you exactly what I mean, because sometimes it's hard to talk it up like
screen for you.
All right, so let me just show you some of the slides that depend on chokehold. I'll blow this up a little bit more so you can see it. This says chokehold is a deadly force option, defined directly as pressure on the person's trachea or airway. But a neck restraint is non-deadly force action, defined as compressing one or both sides of the person's neck, legs or arm, with an arm or a leg, applying direct pressure on the trachea or airway or the front of the neck. That's the one where you can't do, right? So you do anywhere you put pressure on the neck except for the airway. That would be a neck restraint, which is non-deadly force. And then they give you this. Let me show you here is, and this is after they're handcuffed. So it says, okay, they are in handcuffs. Now what? Sudden cardiac arrest is typical, occurs immediately following a violent struggle. Place the subject in a recovery position to alleviate provisional asphyxiation. Once in handcuffs, call EMS and all this. So, and then they have this little picture, and you see, the same way. This is the handcuffing them. And they talk about when the suspect is handcuffed and resisting, you can do the neck restraint, putting pressure on the side of the person's neck. That's that's a restraint technique versus putting pressure on the front of the neck. And at the end of this, they go through this case. And this is from St. Louis. They put this in the training material so all the officers can see. Let me rotate this one more time. Sorry about that. Rotate counterclockwise. Here we go. So they had this case. And I looked up the case too. It's a fascinating case. But this person, the same thing happened to him, except instead of 8.5 minutes, he was being asphyxiated for 15 minutes. And it was another in custody, handcuffed. He had caused he had tried to resist. They put the handcuffs on him, and held them down, and they were cleared. These officers were cleared in this thing, but this guy was killed, and his thing was for 15 minutes. His name was let me look at, I forget the name of the guy. His name was the guy who died, Brian Gilbert. So his name was Brian Gilbert. He died. So looking at this, the fact that they give them this case, they see that they can do this technique, and somebody actually died in this case, and the officers were still found not liable. It makes it more difficult now to say that these officers weren't directed in some way to do this. Now, that doesn't mean just because you train an officer to fire a weapon doesn't mean every time the officer fires a weapon it's justified, right? Just like in this instance, not every time this technique is used is it justified. But now I think you go into start arguing now, instead of whether they could do this, whether they did this to a way where it's excessive. Because I think that's the response that you would have to have looking at these documents. And when you go, it's very meticulous in telling you where you can apply pressure on someone's neck, which is scary. They've just abolished this policy too. After George Floyd, they abolished it. No more putting, whenever you touch someone's neck, that's deadly physical force. Because and it's actually true. Most people think that it's only the airway, but the side of the neck is just as dangerous as the airway. But now, this was written, whenever it was written, it just wasn't updated. So at the end of the day, we may be getting to a situation here where these officers were trained, as you can see, were trained to use this technique. But now, did this officer use this technique in an excessive way? And now with this case that they put in the training material where someone did a similar technique, not the knee to the neck, but the positional asphyxiation for 15 minutes, and someone died and they were cleared. That's also going to lead to what would a reasonable officer in this position think? With all this stuff, and they called them to do this, and you had the same situation, handcuff suspect, acting erratically. You do the technique that they trained you to do. Was it too long? Maybe that might be the issue. But now you can see that this is just not a runaway. This is going to be a little battle, I think.
Yeah. And for those of you who may not remember, just to give Nate his bona fides, he used to be a former prosecutor. He used to be a former police officer. So he can obviously talk intelligently about how police are trained, maybe not about the medical aspects as such, but he can talk about how police are trained and what kind of trainings they receive in briefings, and comment intelligently, at least about these slides, because he's seen slides similar to this in his career. But yeah, I think the prosecution has options. The way that the officer did this knee on the neck thing is not quite in line with the diagrams. There's many aspects in which it deviated from the training, in putting his weight in too heavily on his neck, in terms of not getting him in the recovery position and keeping him there for such long periods of time, and not calling for EMS sooner. In a whole bunch of ways, it deviated from the training. And of course, the big sort of sword that the prosecution has is that the crowd and his fellow officers were telling him, you need to put him in a recovery position. He's having problems breathing. He needs to be changed. And he was just defying it. So he was being actively warned and actively reminded, which helps a lot to show more of the intent, because it's a conscious disregard. At least that's the argument, right? It's not that, he forgot in the heat of the moment and he just, he somehow was just more reckless in his thing. The fact that he's being actively warned, actively reminded, in that he's defying not only the crowd, but his fellow officers and other people, people who had trained in medical. I think there was a nurse who tried to intervene. I think there was a firefighter who tried to intervene, and we're trying to warn him. Goes more to the conscious disregard, which goes a lot more to intent. So it's not like the prosecution doesn't have options, especially for how long it went and how severe it was. And the fact that he had that cold, dead stare right into camera with a look that says, "I am in control. I am God. No one will tell me what to do.
Oh yeah,
I am the end all be all omega." That's not helping.
Yeah, no, I want everybody to understand. I think these cops don't really have a shot. what we're doing is we're going through a academic legal exercise
Sure.
on what would be some of the best options for the defense and for the prosecution. Now, obviously, I think the defense would be foolish not to bring up the same objections that we just made. Right? Here's a training. Here's this. Look at this. This guy has a knee on the trainee's neck. You know what I'm saying? This is what they tell us we need to do. So to get that justification. But do I think it's going to be successful? Whenever officers use force in any situation, it's not just what happened at the end, that somebody died. You have to look at the totality of the circumstances. Actually, the law demands you look at the totality of the circumstances to determine what's reasonable or not. And here, and for instance, I was telling Kurt about this earlier. If you're law enforcement, you'll know this about officer subject factors. How many, or for instance, if you have one officer and 5 suspects, then it's going to be less likely you're going to use force or prepare to use force. And then you also think about things like age. Instead of with 5 suspects, they're 5-year-olds versus or 5 women who are in their 90s. Things of that nature.
What is reasonable is going to be factually dependent, right?
Yeah, but a lot of people think that when you look at the Floyd particular situation, you do have to start putting all those other things into account. 5 X amount of officers, 1 officer. He was handcuffed versus he not being handcuffed. At what point would it be reasonable to understand that he's in a prone position? The materials, the training materials, do say you're supposed to put him in take him out of prone position as soon as possible, and it does warn about positional asphyxiation. So I think it's interesting. When you look at the case, I don't think it's a runaway, but I do think it's a position in which I think these officers have an interesting defense. And I think their defense, their probably best defense is going to be the justification. We were justified in what we did. It may not win, but I think that's probably going to be their best shot, if any.
Yeah. Now, I think this is an interesting comment just because it might speak a little bit to how lawyers talk and how we communicate and how sometimes we're misunderstood. Anna Elizabeth says Nate account of the case is bizarre. It sounds like it comes from a conspiracy website. And I don't perceive it that way. And I'll tell you why I don't perceive it that way. One of the things we do as lawyers is like when we're trying to look at things from one side or the other, we're trying to look at the best possible arguments that might exist that are within the bounds of some version of plausible. So we're not necessarily saying that we think that this is necessarily true. We're saying that if we're arguing this from the position of defense, or if we're arguing this from the position of the prosecution, here's sort of the best arguments that we think that we can conjure that bear some sort of relationship to reality. For example, when I was saying about the causal factor and what actually causes death, so what we have to show is that the police, what they did is completely disconnected from his death. Some factors, some combinations of factors other than what the police did. The police cannot be a factor. So the police have to be removed from this equation. Okay, if you want to try to prove that, how can you do that? Here's how you would try to do that. You'd say, there's these tablets in the car, there's these tablets in the cop vehicle, he took the drugs with combinations of stuff in his system, the toxicology, causes death at that moment. The police are completely disconnected from the situation. Now, does that mean that we think it's necessarily true? No, it doesn't. It's just like, here is if you want to try to argue this case, here's the best possible thing we can dream up. And from the prosecution's standpoint, we're saying, okay, if you want to prove this from the prosecution standpoint, what are you trying to do? It's like, you put these things together and you lay out this kind of argument.
On the defense side, before you go to the prosecution side, one thing I think people fail to realize too is that how hard it is to prove, right? How hard it is to prove the cause of death. One thing is the factor. Now, sometimes it's just easy. The gunshot wound, for instance, this.
Sure.
But a lot of times the cause of death could be a multitude of factors, especially someone who is unfortunately as ill as Mr. Floyd was. Mr. Floyd had hypertension. He had heart disease. He had this. He was the classic eggshell plaintiff. So you can't use that against him. You can't say, well, he had heart disease. He died of a heart attack. Well, but were what the officers did help precipitate that. I think the biggest issue for these officers is going to be those 2 minutes after Floyd became unconscious, and this guy kept his knee on his neck for the 2 minutes after that. I think that's when you really got to solidify that unreasonable. Was it unreasonable? Because you already had 6 minutes down. He wasn't moving, and he was in a prone position.
Right.
That I think is going to be hard to overcome.
No, yeah, no, I'm not saying it would be easy. I'm not necessarily even saying it's a good idea to argue it, because credibility is everything before the jury. And if you make an argument that is borderline, or you'll lose credibility on better arguments. So one of the things you have to consider as a strategic matter, whether it's on trial or appeal, you have to consider whether or not you really want to raise weak arguments, because it can undermine strong arguments. So that's a tactical strategic consideration. And so the defense might be best served by doing it not at all, or doing it superficially, and focusing much more on the underlying felony elements, because it seems like they have a stronger case there, which is why I was saying Nate convinced me on that they have a stronger case there. I thought that the underlying felony was more a gimme, and I thought that the causality factor was a little bit more open, but Nate has convinced me that I'm wrong. See, I listened to my friend Nate, and I considered his perspective, and I'm like, hey, you know what? I think you're right. And I changed my mind accordingly. This is what happens when we listen to other and consider multiple different points of view. It's like, no, wait, actually, you're right. The causality factor is a bit more of a lost cause, and the underlying felony elements are a little bit more open because of police training that we talked about. And you could, if you're the defense, you argue that they're kind of mere technical violations that don't really care. You basically hand wave them away and be like, these are not the droids you're looking for. At the other prosecution, you're like, no, it's a little bit more than that. Here's 18,000 ways they deviated from protocol. And the fact that they were actively ignoring everyone who was actively warning them at the time about the deviations of protocol suggests a little bit more of conscious disregard, malice, intent. So, yeah, but the defense has some options.
But remember, this is not about intent, though, right? Because they didn't. Because this is actually second degree murder. It literally says without intent, murder without intent, right?
Well, the death occurred without intent.
Yeah,
the death occurred without intent. You still need intent for the underlying felony.
Yeah, you definitely yes.
Yeah,
I'm talking about intent for the murder. That's what I'm talking about.
Yeah, you don't need intent related to that. That's true.
I don't know.
Yeah.
Go ahead.
No, I was just saying, you don't need to prove that the police wanted him to die. You don't need to prove that. You just need to prove that they intended to commit the felony assault, regardless of what they hoped would occur as a result. And they committed the assault, so they can't say that they didn't commit the elements of the crime. So then it becomes an issue of some sort of justification. This is our training. Here's some gram analysis. Here's some best practices that we were taught. We were being reasonable under the situation, excited delirium. He was out of control, blah, blah, blah. Fill in the blanks, a little razzle dazzle, Chicago style, and you hope for the best. Could work.
Yeah, I think. Well, don't forget, number one, they already turned down a 10-year. Right, Chauvin was going to plead to 10. The prosecutor turned that down. I think they have a strong case. I think third degree may be a little iffy, especially on the legal.
Yeah, I'm not sure how you get third degree on a legal frame. I don't know how that works.
But the Supreme Court has not given cert on that, so they're going with that. But then you also, I honestly think you got manslaughter probably hands down. But it's the defense does have, I think, arguments for maybe the other officers, like for the officer who was there for like 6 months or something like that, the brand new officer, right?
Oh no, he's like there for a week. Basically, it was his first week on the job, absent training. Wasn't he like 4 days on the job or something ridiculous?
Yeah, you got officers there. This is part of this. You just came out the academy. They just trained you, to do some of this stuff. How do you know that 8 minutes is too long? Even though I think a reason, and then even the case in the training manual, the guy, they had him down for 15 minutes. So
couple good questions here I'd like to answer. Question: do you think any of the four are not guilty, and what do you think the sentence will be? I think that the other officers, other than Chauvin, are not guilty, in my opinion. I don't, because basically they're being charged as accessories, and I don't really think you can get there. I don't think you can show their intent to effectuate or advance a crime. So I'm not really buying them as accessories.
The assault.
I don't.
They're accessories to the underlying assault.
But I don't. The other three officers are being charged as accessories to the assault. I don't buy it. I mean, my opinion, I don't buy it. I don't see it. So I don't really see that the other three officers are guilty of anything. I think Chauvin is probably guilty of second-degree murder, is certainly guilty of manslaughter of some degree, and the sentencing, who knows? I mean, not super familiar with how the sentencing range for those crimes in Minnesota is, but presumably it'd be something very serious. Do you have any thoughts on that issue specifically about the other officers' liability?
I think the newer guy, the one that was standing up, I would say he would probably be the one I would find least to be guilty, and that's because he's doing crowd control, and he's new, and being new and being crowd, like just in the real world, This guy Chauvin's got 10 years. He got these other, monsters. Chauvin had like 3 commendations. You know what I'm saying? Who am I 2 days on the job to tell him that he's not doing something correct, right? So
wasn't he his trainer as well? Who am I to contradict this 25-year-old veteran being 4 days on the job? Yeah, it seems like that's going to go super well.
So I'm just saying, just realistically, that's just my personal thoughts on him. Chauvin, I think Chauvin has a problem because I think Chauvin was a buff, and I think Chauvin, when he did the knee on the neck thing, and they told him, I think Chauvin's I think his culpability turns when they said, let's turn him over to the prone position. And the guy asked him that twice, right? He said, hey, should we turn him over to the prone position? He did not. He said, no, let's keep him here to EMS. Then the guy said, hey, he stopped moving, let's turn him over. And he said, no, let's hold him again. I think you get to second degree murder.
And there's also the idea that the other police officers had some sort of duty to act or some sort of duty to intervene. So let's discuss that as an idea, because normally, as we know from my channel, the police, and for that matter, anyone, don't have any particular duty to intervene with respect to anyone in particular. We can cite Gonzalez, or we can cite Castle Rock, or we can cite Winnebago, or we can cite Warren VDC for these propositions. However, that rule does not apply to the police when someone is in custody. The police, and for that matter, prison guards, have a duty of care to people that are in their custody, because the people in their custody cannot care for themselves. So the idea is that the other 3 officers would have some obligation to intervene because they knew or should have known from their training that this person was under a threat, and they had a duty as a result to act. Now,
and that's where that statement could come back to bite that officer. Turn him over. The 2 times he knew that something,
which might be sufficient intervention. I mean, it might be sufficient intervention legally, but I don't really buy it, because I do understand that the police have a duty to intervene, but I don't really think any of the 3 officers were really in a position to intervene, based on my personal opinion. And to the extent they did try to intervene by actively warning him and actively trying to counsel him against. The person who's trying to guard the crowd is too busy trying to guard the crowd. The person who's next to him is warning him. The other person, I forget exactly, but I don't really buy it that any of them were in a position to intervene or acknowledged to intervene. And if they did, I think they did intervene sufficiently. But the police do have a duty to intervene, so that's what they're trying to go with here, a duty act, and they didn't act. But I don't personally buy it, but that's a personal opinion.
Yeah. Well, I think, I got to see the other charges for the cops, because I would say also, too, you may be able to get them, you might be also get them for assault, right? They were holding them down, too. And if it's positional fixation, you both get the neck, and you also get the whole thing when a lot of people don't know the classic positional fixations, when the guy's under the car fixing the car and the car falls on them and your chest can't expand. Well, the same thing happens or can happen to a suspect that's handcuffed in the prone position. And if you sit on top of that person's chest can't expand, and it's harder for the diaphragm to work, and eventually it just gets tied and stops working. And that's what they believe that happened with George Floyd.
Yeah, I mean, if your chest is pressed to the ground, the ground doesn't give when it's cement, so that's going to make it really hard to breathe. Yes.
Yeah, but so that's why I think the officers on top could also have, you could be talking about also an assault charge for them. But I don't know exactly what they're charged with.
Yeah. I don't personally see it, but I suppose that will be developed. Stephanie asked, does Minnesota have a felony murder rule? Yes. It's second-degree murder. That's exactly what Chauvin is being charged with. The underlying felony in this case is felony assault, because somehow that qualifies in Minnesota, because they don't have murder doctrine, which is insane, but that's apparently the law in Minnesota. So, we're using the felony assault as the predicate felony in a felony murder trial. That's exactly what's going on here. So, yes. And then there's this question, which can lead us a little bit into discussions about some of these motions in limine that we've seen. How do you feel about the first responder in the crowd directed to have limited testimony? Cannot say, I could have saved a life, and then someone said high on level, and so on. So we can talk about the question that was actually asked. It might be interesting to also talk about some of the other motions in limine. So this first responder in the crowd is being prohibited from talking about, if they had acted, that they could save them. And the
Yes.
reason is because the judge deemed it to be too speculative. It's like
And
you
he's not an
can't
expert too.
can't
Yeah.
really know that, which is fair enough, I suppose. The person can testify about what they personally observed and personally witnessed, but they can't say, if I'd been allowed to intervene sooner, then the person would be saved because, well, first of all, it's a bit speculative, and second of all, it's kind of going to the ultimate issue the jury has to decide about, like, what was the cause of his death? Was it the police? And you say, well, if I intervened, he could have been saved, then that is a bit more prejudicial than probative. So I kind of buy that. What do you think about the question that was asked?
Yeah, no, I agree 110%. I think you're looking at, that's more of an opinion too. You're looking at expert testimony for that, and what's the reasonable basis on that,
Yeah.
I think, I don't know. I assume that the judge is trying to get all that bias out, and I think you can testify that you were there, but something like that would just be it is way too speculative. Unless this guy can say, his training and experience just where he can see this and he saw this and he can put together the science. But other than that, I don't think I wouldn't allow it.
Yeah, and we could also talk a lot about some of the other things that have been brought up in the some of the motions in limine. The one that I liked in particular was this guy who was a witness to the events. He was there in person, but he's also a trained MMA fighter.
Okay.
And so the prosecution wanted this guy to be able to testify that he recognized this as a blood choke. I believe was the term they were bandering around, but basically that he recognized the choke. And of course the defense said no. And the judge ruled, and I think it's a very reasonable ruling. I think he could have been the other way reasonably too. And there's latitude here, but it's reasonable to say, no, this guy from his own training and experience, he can recognize this hold and recognize what it is and recognize its effects because he has training and experience. So he's basically simultaneously a fact witness and an expert witness, which is a bit unusual, but it makes logical sense.
Yeah. Well, it's good because it also gives you that true impression of, because so everybody understands what I'm talking about. A lot of times experts are not there at the scene to see the events that they're recording. They're telling your opinion after it. So to actually have one that's kind of both, it's going to be pretty good for the prosecution because they're going to
prosecution. Yeah.
But
I was there. I observed it in person. I saw it with my own eyes.
Yeah,
Here is the thing I recognize. Here is how I know it is because I've been trained in this domain. I know that these holds are bad because of the results, because of all the training I've had specifically in this domain. It's pretty good testimony. Good for the prosecution. Not so good for the defense. Very reasonable decision.
Yeah.
Probably could have gone the other way reasonably too, but it was a reasonable decision from the judge. So I'm cool.
Yeah. Yeah, I would think so.
Yeah. So I really like those questions. And someone also asked, are the officers being charged merely because they were there? No, merely being there is not enough in and of itself to be charged with anything. It's either that they did something or they should have done something, right? That it's that they committed some act that they shouldn't have committed, or they didn't commit some act that they should have, right? So that's the affirmative duty doctrine, which doesn't normally apply.
But also to this is more of the in furtherance of the crime, like the lookout, for instance, in a bank robbery, right? The person who looks out isn't really committing the bank robbery, but their actions are in furtherance of the underlying crime. So I think that's what these other officers are being.
Yeah. So this goes to Q Square's question. I should have put it on screen as I was answering it. Yeah. The people who are not officers can't be charged because no one who's not an officer has a duty to act. People in general have no duty to act. I can watch you being murdered, or I can watch you drowning, or I can watch you anything and choose not to intervene. Maybe it makes me a jerk, but I have no legal duty to act. So everyone in the crowd has no obligation to act. And if they try to act and they're rebuffed, then okay. Yeah, so none of the people in the crowd can be charged with anything. The only people that can be charged with anything for failure to act would be the police officers because they have a duty that emerges from the fact that the person's in custody. So acting, it doesn't matter about anything.
I do want to coach that, and just so people don't take it as an absolute, there are certain situations where you do have a duty to act. If you're your children or something like that, if you have,
I perhaps slightly misspoke. I slightly misspoke by somewhat implying this is the only example of duty to act, and I didn't mean to say that. So if what you heard me say was this is the only situation in which a person has a duty to act, that was not true.
No. I
you
just
have a duty to act to your children. Yes,
Yeah.
you have a duty to act if it's a matter of contract, so you can
just
contractually obligate yourself.
like these sworn officers, for instance, they have a
Yeah.
duty to act.
So there are other examples. Yes.
Yes, I just because I know like how it'll be. People are like, oh,
No,
there's no duty for me to
okay.
do anything.
No,
Like, hold
that's
on,
okay
hold
because
on.
I'm misunderstood all the time on my channel because of things I say, and I didn't really say things, and people draw conclusions, and I'm like, yeah, I didn't really ever say that, but yeah. So yes, this is not the only situation in which you have a duty to act. It's a example. It's against the typical rule, but there are other exceptions, like all good rules. Yes.
Yeah, I think at the end of the day, I think the prosecution obviously has the better case. If you're a betting man, you should be betting on the prosecution.
No, I think that's right. Jury. I think the prosecution has a better case.
You got the tape, and no matter all the legal mumbo jumbo, it's going to come down to what what do you see on the tape. But I do think if the defense, if they can do a good enough job at muddying the waters. Hey, listen, this is what these people are trained to do. Here's the training materials. Here's the case. Why would you give them a case to let them know they can do this and they'll be protected if you didn't want them to do this? So I don't want to undercut how strongly I think that piece of it is, because think about it. If these cops can prove they were justified, then they walk, right? This is a walk for them if they can prove they were justified. But sure. I think it's going to be less for Chauvin and more for the other cops. I think the other cops.
No, I think the other office liability doesn't really make sense to me personally. I think charging them, particularly the ones that are new, is like doesn't really work for me. But Chauvin, because first of all, he's directly responsible. Second of all, he has like 25 years of training, so like his liability becomes a lot more obvious. I mean, if it had been the guy 4 days on the job who had done this, then the liability becomes a little less obvious. But it's Chauvin with 25 years of experience and all the rest of it. It's like, that's a problem. Yeah. Isaac asks, how do you feel about the judge's directive limiting the reference to people in the case? For example, police officer XXX and victim XXX. Yeah, so the judge gave a kind of a soft instruction on this. The judge basically said that he prefers if when you're referring to people, you refer to them as Mr. or Mrs., as the case may be. So he prefers Mr. Floyd or Mr. Chauvin or whatever as a general rule. But he also said that he doesn't really believe in micromanaging the lawyers. So, if for some reason they feel like they should do victim or some other thing, then they're okay with that. He just, as a general rule, would prefer to try to avoid it. And that makes sense because it's a less prejudicial term, both for good and bad. If you just refer to someone as Mr. or Mrs., refer to them as officer or victim, it's a less prejudicial term because it's more of a neutral thing. So it makes sense to me logically. Yeah.
Agreed.
So I think so far the case is going pretty well. The rulings from the judge seem to be right on the money. Let me temper that slightly. I could see a different judge making slightly different rulings in and being fair, but I think everything the judge says has been a reasonable decision. I could see him going the other way on the MMA fighter. I could see them going the other way on some of these other issues, but the decisions that they've made seem within the bounds of reasonableness. So even if the judge would have gone the other way, there's enough latitude there to allow for that. So I've been happy with it so far.
One thing they talked about earlier today too was propensity evidence, and how they were afraid they didn't want to open up the door to Floyd's past, obviously the drug use and some of the violent stuff in the past.
It doesn't make any sense to bring it up.
Well, it's an open a door issue. See, there was a couple of witnesses they wanted to say, Floyd was peaceful, he was this, he was that, in the car or whatever. And then they were saying that the defense was like, well, if they're going around saying he's peaceful, they're opening up the door to, these times that he wasn't peaceful. So so the judge kind of, threaded the needle and said, well, if it's reputation in his reputation in the community is this, or his reputation in the community is this, then there'll be some latitude. They won't have opened the door. But if they say no, he was a peaceful guy, then you're able to bring in the evidence that he was not a peaceful guy to challenge it. You really can't challenge someone's opinion of someone else.
Really,
unless but that even qualifies too, because if I'm talking about his reputation in the community, that's one thing. If I'm talking about do I know him? And did you know he was convicted of X? Like, hold on. I did know it. Well, then if you do it, then how can you say he was peaceful? If he was convicted of something like that. So it's interesting,
absolutely.
but we'll see. We'll see what happens. I think the trial is going to be short and sweet, but I really
I'm not sure about that.
It.
I'm not sure how short or sweet it's going to be. I think it's going to be 3 weeks once we actually get into it.
Yeah. But what more do you have to play? The big thing is they're going to play. The thing the defense got to get through is the tape. They got to get through the tape.
Oh, they're going to get the tape in for sure.
I know. No, I'm saying, but they got to get through the tape. And they got to get, number one, I think you got to. I think their video has to be the body cam. I think if I'm the defense, I'm all into the body cam and I'm narrating the body cam footage. Here's what happens when these officers get. Here's the call for service. These are, these people are asking for the police to help. They just try to pass a counterfeit bill. Go through all the steps, walk people through the police officer's day. How they go bad, why they go bad. That's where I think they can get some sympathy. But I think at the end of the day, it was just, excessive force can happen in an instant. And I think that's what happened here. I think you had this excessive force happen in an instant, and they were just too, I think the cops, and I think Chauvin, for instance, was just way too buff. He was way too excitable to recognize that he had gone too far. And unfortunately, this guy lost his life.
So good question here. In terms of the state of Floyd and cause of death, how will the judge instruct the jury to understand if the police was a cause is enough?
Oh,
or how
the jury instructions. Pull
the
jury instructions.
The jury instructions are mostly
they usually have them published.
Yeah, they're published. And so there's instructions for everything. They can be modified if they need to be, but pretty much everything's been thought out because of many appeals that have occurred before. So you look to the standard instructions and you give them the exact wording and instructions. So I couldn't quote them verbatim off the top of my head, but there's instructions basically saying that if you find this, and if you find this, you must rule this way. If you find this, you must rule this way. So the exact languages in the jury instructions, and they can be modified. But yeah, it's how most of this has been established because it's not the first rodeo, right?
Yeah.
So what else do we have to discuss other than Floyd Chauvin, since we spent an hour talking about that?
I don't know. Anything new did they drop anything new with the Katie Joy lawsuit?
I don't believe so. Not since I last covered something. You did want to talk about how your impressions of Brown, though.
Yeah, but I don't know. I think I'm losing it with Brown. I'm losing it for Brown. At first I was pretty. Well, I've never been really hyped on Brown, but I think he's got himself really in a pickle here, man. This thing is just like unbelievable. Like the stuff that he's been doing. If it's not what I expect for $450.
No.
Does that make sense? It's not what I expect for $450.
No, I'm on board.
The motion to dismiss was lacking. And now these subsequent motions, what's the purpose? How's it going to help my client? And what are we doing here? You're looking down the barrel of an angry judge now,
Mm-hmm.
I don't know. What do you think Brown's strategy is? His strategy here is?
I don't know. Brown is really aggressive in ways that are not helpful. And this is a criticism I've made of him before, but he takes pretty much the most negative interpretation of what's happening at any given moment and runs with it. So in some ways, everything he says is plausible on some level, but it's always like the most negative version of it. He doesn't seem to accord anyone any kind of grace or slack or anything. And he seems to think that opposing counsel, or at least the way he writes, opposing counsel is always, in a nefarious state, for lack of a better description. He doesn't seem to have a lot of grace, and it's really unfortunate for the profession, because a lot of this is being exacerbated by Brown. We're on to filing. I don't even know what filing we're on. Let me just check real fast. We're on filing, or we're on docket entry. Where are we in this thing?
Yeah, we're
65. We're in docket entry 65 that was filed on March the 3rd. So we're still 65 docket entries, and we still haven't solved jurisdiction. Wow. That's insanity. It's insane.
But do you blame the judge? Is it more down a blaming of the judge? Like, come on, really? Like, what are we doing here right now? You know what I'm saying? You got to get a little bit more control over this stuff, no?
Yeah, I mean, I'm surprised the judge didn't order an STFU motion long ago, because this is all so off point, and just deal with the jurisdiction stuff, because there's more than enough there to deal with this issue. I mean, we haven't had anything about jurisdiction in, I don't know, 20 filings or something.
And
Maybe more than that.
And I honestly think the jurisdiction is a loser. I think Brown's best argument is the jurisdiction, because again, if the court finds jurisdiction based on these facts for for Toddy, that's George. I get jurisdiction in Washington, and so do you, right? Because you're going to have some fans from Washington State.
That is a logical consequence. And this was interesting too, because I was dealing with some people who thought that I was biased in my in some of my legal conclusions, because they're like, you're biased as a YouTube creator because they say, well, you want Toddy to win in part because if Toddy loses, you think it creates more liability for you. And so that's biased. And I was thinking about that. And I was like, well, then I don't know exactly what an unbiased conclusion would look like here. Because when you're saying what should the legal result be, that's more of a normative question, right? So you're saying, well, what is the best legal result in this situation? And when you're asking a question like what's best, that's normative. What should the norm be? And so I don't know what an unbiased conclusion would look like, because any answer that you could come to for what's the best legal result will be based on your prior experience, prior training, your incentives, your priorities. And so I think I'm I'm not being biased by the parties. I'm not being biased by the people involved. But when you're asking like a legal question, like what is the best legal result? It's like, I'm not sure how that's possible for that not to be biased in some way. What does an unbiased conclusion even look like?
That's true. Well, I think, yeah, I understand that. I think people don't understand when we read these cases. We're reading them trying to find the holes and the breakdowns, and trying to do exactly what we do. We're trying to tear it apart, right? We are trying to find where the person did well, where the person did poorly, and tell you guys about it, and tell you guys how we react to it in real time. So a lot of times, like even with what we just were talking about, people would think that me saying, well, I think the defense should do this, is this me somehow advocating that the defense should win. And the same thing with you with this case, with this, I believe that she can win based on this. Now you're advocating for it, or you're pointing out some weaknesses in Saltz's case. I think people have to just understand that's what we do. We're legal commentators, and both sides, like I feel, even though I'll say I do have a bias toward KJP's side, because I know that's somebody who I know, my legal analysis, I think, is I can separate that, because I can clearly state why I believe her case is a better case. Based on what I've seen, based on my experience. Obviously, I'm like for a jurisdiction, for instance, the reason why I believe that she should win is because it would open up the door for all of us to have jurisdiction in Washington, right? That doesn't make sense for somebody to be able to bring me into Washington court because they sent me a super chat, or because I looked at something on an internet site. I just think that just would not be fair. That has nothing to do with my friendship for her. That's just my legal analysis, right? And then we're talking about the defamation piece of it too. I just believe that they're public figures, right? I believe that all three of them are public figures, right? And the reason why is
I'm less convinced on James, but I think it's arguable.
Yeah, I'm like 90% that James is a public figure, right? It just when you look at the amount of videos that he's in, the wedding video, the engagement video, this is my boyfriend video, then all the videos that he has by himself, a man's best pick for combs or whatever they do. He's got millions of views on those videos. So he is a public figure, and he's her business partner, right? So I'm thinking if you just put all of that together, and if they say he is a public figure, then that's it. It's ball game. It's just something that's going to be hard to win. So I don't know. I'm trying to be fair in my assessment. Like I also think too, the motion to dismiss was bad. I've said it. Kirk has said it. We've all believed the motion to dismiss was
was horrible.
Yeah, nobody's sitting here defending that, but we think that
show me any legal commentator who thinks the motion to dismiss was good, right?
Brown.
Yeah, apparently, I guess, but man, it's like it was a train wreck.
But just because it's bad doesn't mean that they can't win now, right? I think there was a bad motion to dismiss, but I don't think the argument I think is still sound. There is no personal jurisdiction over a Minnesota defendant. It's I think it's winnable, but I think it failed. I think they should have fought the defamation. I think that's what you do. What did Amber say? Amber says, I think you, Uncivil Law, and Nate, the lawyer, do best looking at the case with the most unbiased eyes. Oh, thank you. There's always.
I'm trying, but I posted I pinned a comment on my last video. It's like, you're so biased. I'm wondering why you're so emotional. Like, I cannot make these people happy no matter what I do. It's like I cannot. I don't know what an unbiased opinion looks like to these people at this point.
I think. But the thing is, I think people need to understand it's not about my bias, right? It's about my reasoning to why I got to that opinion. Now, I may have some biases but if I give you, if I say here's A, here's B, here's C, and this is how I get to D, if you could follow that reason and logic and agree that the reason and logic is sound, that's different. That you can say, okay, even though he has this opinion, I don't really, he's explained it without the bias, right? But now, I think a lot of people just don't want, a lot of people's own biases kind of impose their bias on me, because I'm not saying what they want to hear.
Yeah, I guess so. There was one other case I wanted to ask you about, and I hadn't really prepped you about it, but I just brought to mind. So if you have nothing to say on this right now, then no problem. But there was a case dealing with a 1990 cold murder case with a car bomb in Long Island. So I thought, being a New Yorker, you might be somewhat familiar with this. This is like a 30-year-old court case, or 30-year-old.
I think that's before I was in. I don't think that was before I was in high school. It was like
so it might be interesting to discuss sometime. So I'll send you the article so you can take a look at it and maybe see if there's anything to comment on. But apparently, there's been some new investigation that's been reopened in regards to that. So it might be interesting to see what you had to think about it. But sorry to spring that on you. It just came to mind.
No, it's fine. Right now, I think at the end of the day, with the KJP case, I think at the end of the day, I'm assuming they'll get a kick for jurisdiction. Toddy seems to have deep pockets because this guy is spending hours on the phone with Marianne.
I think it's interesting because we've come out on opposite ends of the jurisdiction argument in terms of the probabilities of what will happen. I would like KJ to win, but I think the probabilities favor Toddy, and I've said that. So I think it's 65 Toddy to win, even though I would like KJ to win for the reasons that we've discussed, which I think speaks to my non-bias, or at least my objectivity, because I'm like, what I think I want is not the most probable events. So,
well, I know I'm going out on a limb here. I'm saying this one. My prediction is that this won't go to trial. Now, if they settle, obviously all bets are off. But my thing is that this will fall. If it doesn't fall to this motion to dismiss, which was poorly written, it's going to fall to the on the next stage to what's it called, a motion for summary judgment.
Yeah. Well, no,
I don't think you get past that.
No, we're not there yet, because once we decide jurisdiction, the next thing that's going to happen is presumably the answer. Yeah, and then Katie Joy gets to bring counterclaims. I'm not exactly sure what those will be, but I'm sure we'll dream up something. And then we're on another motion to dismiss.
Yeah,
and then 18,000 precipes, because apparently that's the order of the day. And maybe somewhere around docket entry 250, we'll start talking about discovery or something, because that's the way of things. It's like, that doesn't make any sense.
But now, can the issue now is, though, can KJP continue to pay this, though? Because this is going to get expensive.
Yeah.
If it's not,
I don't know how KJ is affording this. I really don't. I don't know how she's affording it. There's been speculation, and I have no information one way or another, so I have nothing to offer on this factually. But there's been speculation that Toddy's business partner is in some way financing this as some sort of alternative discovery mechanism, or whatever the motivation would be. I mean, that would explain some things, because it could be financed by someone else, but
you won't get that even in discovery, though, because how your lawyer's finance is privileged. Who pays your legal bills are privileged? I'm not talking about.
I wasn't saying that was discoverable. Mm-hmm. I was saying that if it's true that he was paying for it, the reason that he might be paying for it would be because he would hope out of this lawsuit things would be discovered by Katie Joy that he could then gain access to that would help him in his lawsuit in some way. So it's an alternative mechanism of discovery for the business partner, because he can use the discovery in this lawsuit to assist him in some way in his own whatever. So that would be the idea. He's using it as some sort of alternative discovery vehicle. So that was what I was trying to say.
But then it's still like, why would you get Brown? Because it almost seems like Brown wants this case to go to trial. Maybe he does. Maybe it's just a financial.
Maybe the idea is exactly to again, if this theory is correct, which I have no information to offer on one way or another, so I'm not offering it. It's just been suggested, and I don't know what people are basing it off of. But the idea might be specifically to frustrate Toddy by keeping this thing going on some ongoing basis, to drain resources, to drain attention, or something. So maybe this is all part of a plan, which would explain a lot maybe about why the way Brown's acting or something. So I mean, I don't know if maybe that's true, but it could be.
I honestly think I expect Katie to win. I expect her not to go to trial. But if that does, I think you just did the reverse, right? Because it'll be the biggest Uno reverse on the planet. Everybody now has read the complaint, which was beautifully written, read his response.
He
murdered Brown. He murdered Brown with the response, Salty's, you spent $200,000.
Yeah, no, I thought
the latest response with the murder.
In terms of the latest response, like I didn't really fault Brown. Okay, let me take that back slightly. Brown again is going to the most extreme conclusions on the page, which is a tendency of his, and I don't really like it. But it was a little bit more justified in this latest response than in other responses, because from Brown's point of view, given what he knew, he could have reasonably suspected that Saltz was talking to Lorianne when he should have known that Lorianne was represented, so there might be some impropriety there, and that the affidavit that she filed was completely unsupported because it contradicted what Brown knew. So Brown was slightly more justified in his suspicions here than he's been in other motions, even though, as is typical, he kind of goes to the extreme end of the page. The extreme end of the page was a little bit more plausible.
Hold on. We got to go back to that, because Brown with the whole Lorianne thing, right? Brown is saying, oh, well, a reasonable person would have suspected she was the lawyer. Here's all the communications, right? Now we find out right after that, right? A couple of days later, Brown. All right, let me explain to people, because I don't want to just go to stream of conscience so people don't understand what I'm talking about.
Knock yourself out.
Brown made a motion, right, to sanction Salty for talking to someone who was his client, which was Lorianne, right? So he files that motion. Lorianne was like this shadow client of mine. Salty should have known that, and by talking to her, Salty, he violated the ethical rules. But by saying that, by doing that, Brown put himself in a horrible position. The position Brown put himself in was that now he had two clients that were adverse. Lorianne had just filed a declaration against Katie Joy. Now, Katie Joy was saying Lorianne got mental issues, right? She's got some issues, right? Kid, don't believe her. Now you have two, and you're representing them both. So Brown is like, oh crap, I got somebody paying me $450 an hour to talk on the phone with Lorianne for 11 hours, and Lorianne who's not paying me nothing, right? So he had to go to the court and he's like, well, hold on. That's true now. I got two possible clients that look conflicted. So he went to Saltz and said, hey, this is, I was never her client. But the problem is that Brown forgot that the reason why you were attacking Saltz was because you were said that she was your client. So then Brown, again, I'm getting Brown and Saltz again, but Brown then had to file this motion to qualify himself. So to have the court say, you weren't representing Lorianne, which Brown says he wasn't. So I think one thing that Saltz did was so beautiful, was he took Brown's motion to qualify that he never represented Lorianne, and he responded to the motion for sanctions with that. Look what Brown said. No reasonable person would have thought that he was representing Lorianne, and for the fact that she fired him the day before we spoke to her. So Brown is, so again, I don't know why Brown, I don't know if Katie is paying for this, But this is, this is a mess, and this is a mess all created by Brown, right? All these motions are because Brown filed them.
Yeah, I kind of agree with all that. Yeah.
So it's not like, again I just don't know what's going on, but we'll see. He's asking, now Salt's got 3 or 4 attorneys on it, so this is going to be monstrous, but it's going to be glorious. Whenever this judge says motion to dismiss, it's going to be glorious.
I thought Salt's response was very persuasive, so I thought Salt's came forward with a very good conclusion at the end of the day. He backed up everything he said with documentation. Doesn't necessarily mean it's true, because there's evidence that would tend to contradict that. But he had enough to propose it on a good faith basis, so I don't really fault Salt's. That isn't to say that you can attack it, because I think you can. But Salt's conduct seems professional, which is very typical of what we've seen from Salt's overall. He had one sort of unprofessional move. He may have had the first unprofessional move, but maybe the only unprofessional move, because he was the first one who said that Brown acted. What did he say exactly? I'm trying to remember back 40 documents. But he said something like Brown acted in bad faith. He might have said bad faith, but he was the first one that kind of made it slightly personal. And then Brown went completely off the reservation after that. But yeah, Salt's was kind of the first bad actor in this sequence. But yeah.
Salt's didn't try to get him sanctioned. Like a little tough wording is one thing. That you have to chuck that into advocacy.
I just said that all I was trying to say is that Salt drew first blood. That was the extent of my claim. That was all I was trying to claim, is he drew first blood. He drew first blood.
No, it's like somebody throwing a pebble and there's somebody launching a rocket launcher at you.
Again, I was not trying to make a claim about the comparative volatility or the comparative strength of the things that are going back.
The response.
Make any argument along those lines. So let's keep it to what I was trying to say. Yeah. So I'm not misunderstood. Yeah. What? Yeah. Brown takes the most. It's almost. I don't know how to say this otherwise. It's almost paranoid in some ways, because he's always going to the most negative conclusions. It's really kind of weird.
Yeah, it doesn't make any doesn't make any sense. It doesn't make any sense on so many different levels. Like just so everyone understands, just strategically, none of this makes sense. And just from someone who just go through it with us.
Unless there's the conspiracy strategy, unless there's strategies that are beyond this case, which would make things make more sense.
Yeah, let's take out the lies and all of this. Let's just talk about the legal strategy. You have a complaint, right? Standard. We recite the standard every time. Somebody was in the chat the other day arguing about the standard. Standard is what it is. All they have to accept everything is true. And then think about it this way. The motion to dismiss standard is for something like a statute of limitations, right? You just didn't file it in time. So no matter what the plaintiff says, right? Everything they could accept it all is true, right? Give it all favorable inferences. But time ran out. So what, right? We call it SOL, shit out of luck. SOL, right? Statute of limitations is run. That's the same way you think about jurisdiction in this context, in any motion to dismiss for failure to state a claim. If everything the plaintiff is saying is true, then on this technical matter, can the case still go forward? No, the statute of limitations ran out in one instance, or the court doesn't have jurisdiction. So just as a strategy, you present that first before you answer, right? Why would I answer a lawsuit? I don't have to. Why do I have to deny allegations, which I don't have to, when you don't have a legally cognizable claim? So that's where we're at. So I like to always say that's where we're at. Katie Jo Paulson has not officially said she didn't do any of this stuff. She hasn't denied any of these allegations. When people say that she didn't do this, or she says she didn't do it, that's just not true. She hasn't said that officially.
Yeah, and she can't, because that would be a merits argument and would waive jurisdiction. So she can't deny anything at this point. She just has to say, even if it's true, it doesn't matter.
Yes.
She can't say it's not true. If she says it's not true, she has a real legal problem. Which in this case would be burning like $150,000 of money on the
So now the issue is that we're at this standard, and she said, okay, well, if everything you're saying is true, and then what do they go do for like the next 70 filings to argue about shit being not true or not true, right? Here's Lorianne's declaration. She says all this. So, okay, you want to argue this for the purposes of jurisdiction. She says we're this close. We said we're not close. But guess what? Lorianne says left. You say right. for the purpose of the motion to dismiss.
Forget Lorianne's declaration. Let's talk about Katie Joy Paulson's declaration.
I haven't even got there yet.
Which is the most mind-numbing thing I think I may have ever seen.
Now, at this point, since all the allegations on the other side are assumed to be true, there's nothing that declaration that Katie Joy Paulson that would be credible that's going to change it, unless she says it happened on a Wednesday and it really happened on a Thursday. She could bring a receipt to show it happened on a Thursday. Something that's just so factually
you have to argue, if you're going to play this game, you have to argue it's palpably absurd. It's irrational. Yes. So it's possible, but it's hard as shit. And nothing that Katie Joy or her side has offered says that anything Toddy has said is like beyond the pale stupid. It all's plausible. So if it's plausible, we should accept it as true because that's the legal standard. So none of this makes any sense.
But it's like the problem that we have now is that Katie Joy has like 4 declarations. That's having your client on the record in a case 4 times before they even denied the allegations. So that's 4 times.
I understand. Nothing makes sense. We should have had this issue. I don't get it. It breaks my brain.
She's literally has 4 declarations before she's even said she didn't do any of the stuff yet, right? She's arguing with Lorian. And those things can be used to impeach her credibility later when she's officially on the record, right? I didn't do this. Well, when you said this, when you said this and these things, were they true? Were they not true? His conflicting statements you made. That's the reason why you don't make so many statements. So that's what we're saying as a legal strategy. We just don't understand why Brown would put his client in a position to give statements under oath that she needs not give at this particular time, because no matter what she says, the court's going to say whatever Toddy says is true.
I don't know if it's a plus or not, but I have content forever. So I got that going for me.
That's true. Maybe we're overthinking it. Yeah, maybe we're just overthinking this. Maybe we're just 2 crazy guys online. This is, hey, just have your clients give as many statements as possible, whenever possible. Who cares? Anarchy.
I feel legitimately like this is bringing our entire profession into a bad light, and I don't really like that because, this is not really what happens in most lawsuits, and people are getting a very bad impression. This looks very sort of drama-y and tea-y and very sort of as the world turns, soap opera or something. And that's not really how law works, and people are getting a bad impression. It's like people who go into small claims court and think it's like Judge Judy, which it probably is not going to be like that.
Yeah.
So this is not really the best vehicle to understand what law looks like. So, yeah.
Well, yeah, because I think the procedural aspect of it is one piece of it, but I also think that people think that it's just like, like a lot of times in the chat, I'll get, why do you have to believe everything Toddy says? Not understanding that this is only for this limited time in space, just to see if she has a legally cognizable claim. And it's not about the merits, that just because we believe we're giving her this assumption now has nothing to do with the merits. So it's a whole big convoluted mess, precipice. Most of these people have never heard these words. But what our job is, and what we hope to do, is take you on that journey, right? Lead you down the path from our experiences to say, this is the reason why we believe these professionals do it. And for Brown, I just will never know. I just will never know why he does what he's doing. I just can't call it. He's an enigma to me.
Fair enough. And someone says NYS RPA is back at the Supreme Court for a new possible hearing. So if that happens, we'll happily cover that. That'll be fun.
No, I told you guys about this case. This is the case I was going to have the president come on my channel.
Of they would get, or the NYSRPA?
That's the New York State Rifle Association.
Yeah, that's cool.
Yes, I spoke to the president, and what they've done. Remember when I did that video about how hard it is to get a carry permit in New York?
Yes, as a person, former police, former DA, apparently you're not trustworthy for some reason.
Well, I can get one. I can just get a letter from my boss, but I think the problem is they want you to get an affidavit from everybody who you live with, an affidavits from people who you used to work with, like all these crazy things, right? I got to get affidavits from people, who I've worked with 2 years ago to say I'm a good guy, which was ridiculous, right? So I was talking to this guy about it. I was like, I'm thinking about suing, just taking it up, them being a former prosecutor, from law enforcement. It's nothing thing, what I'm saying? Why shouldn't they give me the license? But they said, though, we have a case going up for cert with the same license structure. So stay tuned. So he told me after they get it that we could probably get them on. So I'll see if we can get them on and to talk about it. But it's going to be interesting. They think they have a real good. They said the biggest issue that they get is you remember what was the case? McDonald, is it McDonald, the one that incorporated to the states? Heller?
Yeah.
McDonald incorporated Heller to the states. And what that meant is that if there was an infringement on your right to have a firearm in your home for protection of your family or protection of your home, if the court would apply strict scrutiny to that regulation, right? Because it infringes on a fundamental right, your right to have a gun in your home. But the Second Circuit here in New York uses, instead of strict scrutiny, intermediate scrutiny for those cases. So they've been trying to get something to the Supreme Court to instill that the Second Circuit and all the other circuits need to use strict scrutiny when it comes to licensures. So that's what it is.
Yeah, absolutely. Yeah, so it'll be very interesting if you have them on and see what's going on. So yeah, a May issue could be challenged. I'm not particularly optimistic about the Supreme Court taking it, but then again, we have Amy Coney Barrett on there, so maybe we'll see. But yeah, we need to get some gun cases going on somewhere. We need to challenge something. So we'll find out if this is going to be the case. It'll be interesting if the Supreme Court grants cert, if New York goes into a panic again and be like, let's go shell issue so we don't avoid this.
Oh no, they changed the law overnight, right? We abolished it. They abolished the last one.
They did last time, man. They can change the law very quickly when they're highly motivated. We learned that before, right?
But that was beautiful. They mooted it right out. They mooted it like the next day. They were like, they changed this. They about to strike this bad boy down.
All right. Well, I think we've gone on long enough for tonight, so let's wrap this up.
All right, brother.
I want to say that I really enjoyed talking to Nate the Lawyer as always with our weekly catch up. We'll definitely cover some more things. We got a lot of things upcoming. On my channel, we're going to be covering the bridal designer woman with her lawsuit and the contract that she signed and her sadness over not being allowed to be a bridal designer anymore. Covering that probably Friday. We'll cover that in the evening. Try to get started on that. And we got some other stuff upcoming. It should be fun. What's upcoming on your channel, Nate?
To be honest with you, I don't know. I'm in this weird space because now a lot of these police videos that I try to cut are just automatically demonetized. So I'm trying to find some content that I can just do that I can, that are just not instantly demonetized.
It's all about creative rewording around the algorithm. So we can get around these problems.
But it's I enjoy doing the fun stuff, but I'm scared because I don't want to be like R&R. Is he still demonetized? I know they hit his whole channel. Yeah, they hit his whole channel, and now they hitting all these other channels. Like another friend of mine just got a 1 week suspension. So I want to continue to do the police content, but I'm just trying to look for some evergreen stuff. So I might do some. I might be some more educational stuff. Did you like the last one I did, the American territories?
Yeah, it was good. It was really, really interesting. It was a good refresher. I knew a lot of that information, but to see it all collated together was really, really nice.
Yeah, I'm thinking about doing more stuff like that because it's less political and hopefully, it'll be interesting. But right now, I'm trying to figure out this YouTube thing right now because again, it's just like I have 3 or 4 videos in the can right now.
Maybe you and I should try a locals thing. We can do instead of the Viva Barnes locals, we can do the Uncivil Nate.
Oh yeah, that's awesome. That'd be awesome. Hopefully this YouTube thing works out for us, brother. But again, I'll be having a lot more content on. It's just now I'm just trying to find something that I can do that doesn't get demonetized automatically. So we'll figure it out.
All right, I'm going to sign off for now. This has been a lot of fun. So I will sign off for now. It's been a lot of fun. If you're not already subscribed to my channel, why not? Please remember to check out Nate the Lawyer's channel. He's awesome too. And until later, my friends, cheers and goodbye.